Your contention is that Postmaster Gopalganj head office is not the competent authority to regularize the services of
Yes,
the
my lord.
respondent.
He was not a competent authority to regularize. And for
Correct.
that person, my
One
lord.
second. Have you withdrawn that?
Yes,
Have you withdrawn
yes, my lord.
the regularization order?
Annexure 2 may kindly be seen, my lord.
Sir, 7/2/2000, order of regularization of the deceased employee passed by the postmaster Gopalganj has been withdrawn.
Yes, my lord. That
Show
has
me,
been.
show me the withdrawal order.
Annexure 2 may kindly be seen, my lord.
Huh?
Annexure 2 may kindly be seen. Annexure 2.
Annexure 2.
Annexure 2 at page 17, my lord. The subject, regularization of contingent paid staff casual levels. The memos issued in favor of names of those persons dated 9/2/2000
Sir,
is hereby cancelled.
Page 17.
Yes, my lord. As you are,
Is it page 17?
my lord.
Page 17 or 18?
Page 17, my lord. Page 17. Annexure 2. The order of regulation has been cancelled, my lord.
Where is the notice issued to the petitioner, the deceased employee?
My lord.
Where is the notice issued to the deceased employee?
My lord.
Before cancellation of regularization order,
Yes,
have
my
you
lord.
issued a notice to the deceased employee or not? Where is the notice?
The notice was not issued to the.
Then
yes, my lord.
Then it is in violation of principle of natural
Yes, my lord.
justice.
The copy to all the concerned person, number 4, Sri Muhammad Suleiman,
Sir,
husband of Saida
Once
Khatun.
the regularization order is passed in favor of X, he
Yes,
gets vested right over the post.
Yes, my lord.
Before cancellation, he is entitled to notice. Have you issued a notice? How can you abruptly cancel?
I think, my lord, the immediately in the year 2000, the order of regulation was passed, and immediately subsequently the higher authority passed order that you are not competent for regularization.
At the same time, why you are not issued a notice stating that your regularization order has been passed by an incompetent authority, therefore why we should not cancel your order of regularization? Have you issued a notice?
I shall have to seek instruction, my
No,
lord.
from the
Although I think no notice was specifically issued to those persons.
Then this is a void order, void communication.
My lord, but this is against the norms, my lord, against the order.
Correct, sir, but he is entitled to notice.
Since a casual labor with temporary status.
I do understand, sir. You may be having a merit. At the same time, are you not required to adopt a principle of natural justice?
Am I allowed to seek instruction as to whether any notice was issued to the concerned persons or not? Although I am saying that this letter was, copy was forwarded to, the cancellation letter was forwarded to, and no one of them challenged the order.
No, it's all right, but there is it will go to the root of the matter that you have not issued a notice because his right is affected.
I may be allowed to seek instruction below whether they have actually issued the notice or not.
Then who is the competent authority?
My lord, there is a departmental promotion committee.
Huh?
There are several cadres, casual labor.
All right, sir. Who is the competent authority?
Competent authority.
Has it taken any decision in respect of regularization of the respondent's service?
Competent authority as a committee of person who considers and according to the availability of the post, since the temporary and permanent are the posts under regular establishment, and
Sir,
for
but
that
for 12 years there is no vacancy,
25% of the vacancy.
whatever it may be. Where is the material to show that
My lords,
between 2000 to 2012 there is
my-
no vacancy?
My lords, subsequently, the several persons and the persons concerned
Will dismiss the petition.
my lord,
Will dismiss the petition while confirming the order of the tribunal.
my lord, subsequently in the year 19 annexed,
Mr. Counsel,
my lord,
forget that you are appearing for a department. In general, I am asking you, respondent, deceased employee, his services were regularized in the year 2000. He died in 2012, and without issuing notice to the the deceased employee, you have taken a decision that incompetent authority has regularized. Further, assuming that that is correct, the competent authority, has he taken a decision whether the deceased employee is entitled to regularization between 2000 to 2012 for 12 years?
my lord, there is a specific provision for regularization
Sir, all right, you show me the material for this year so and so. The authority has taken a decision.
Your Lordship.
If deceased employee is not entitled to regularization for 12 long years.
Your lordships may kindly see Annex 4 at page 19. Page 19 may kindly
And
see.
his life came to an end while saving your post office.
My lord,
This particular gentleman, his life came to an end while saving your post office from dacoits.
in the year 2012, two ports were found. 25% of the vacancy was to be considered for being recruited from among the temporary status casual laborers, my lords. And two posts were, and for that purpose, their willingness were called for. Since this was to be multitask staff.
What
my
is the
lord.
basis to say that the postmaster is not the competent
Not-
authority? Who is the competent authority? Where have you determined who is the competent authority to regularize the?
My lords, the competent authority have subsequently regularized
Sir-
two posts from among those persons, my
Sir,
lord.
do you
Page 19 may kindly be
do you
seen,
know
my
what is the question posed by this court?
lord.
Who is the competent authority?
Competent authority is the one committee.
Where is that document
My
to
lord.
show that so and so committee is the competent authority?
Your lordship may kindly see page 28. This is Gazette notification, my lord.
Sir, this gazette notification is issued in the year 2010. How is it applicable? The petitioner grievance, the regularization is in the year 2000. The constitution of committee for the purpose of regularization was notified in the year 2010, after 10 years. How is it relevant?
Yes, my lord. That is of 2010.
So you can't rely on 2010 notification.
Your lordship may kindly adjourn
Huh?
for some period.
You want to withdraw
seeking-
this petition?
My lord.
You want to withdraw?
No, my lord.
Then
I pray this may be adjourned for some
For what
time,
purpose?
so that I may seek instruction on this very particular point, whether they had issued any notice before cancellation of their regularization or not, and that the all, certainly they have placed.
And 2010 notification is not applicable.
Certainly, my lord.
Regularization is relates back to 2000.
So I missed. हाँ. Your Lordship, the matter has been raised several times before this honorable court and as well as before the honorable apex court, and I may be allowed to place some judgments before your
Sir,
Lordship.
petitioner is a poor lady. She is
Actually, my lord,
her
this is
husband,
what
her husband died in 2012. We are in the year 2022. You are blocking her entitlement of pension, family pension, and the present petition is of the year 2015.
My lord, I
And it
beg
is
your
pending
pardon,
for
my
the
lord,
last 7 years.
but this petition was filed by some other council, and I really feel that several matters are lacking in the petition, and that is to be supplemented if your lordship, so that the interest of justice may not be hampered. My
Only
lord.
1 week time will be granted,
All right, my lord.
not more than that.
10 days, my lord.
If you do not satisfy this court, we'll dismiss the petition on the next date of hearing.
This may be after 10 days, my lord. 10 days.
Why? You have to get instruction from where? From England.
All right, as your lordship pleases.
Huh?
As your
See,
lordship.
she is waiting for financial benefits.
In respect of several queries made by your lordships, and certainly I have not prepared it, and certainly several essential facts are missing in the petition. Although I have gone through several judgments, and you are those judgments are supporting.
No, first on
but
factual
this
aspect.
basic point is really.
First you have to satisfy this court on factual aspect, then only we'll go to the judicial pronouncements.
The basic point is whether before cancellation any notice was issued or not. This is certainly to be verified, my lords. Although on the record I see that the cancellation letter was subsequently sent to all concerned, and no one challenged
Yes,
and raised any objection.
Matter was heard for some time. This matter is of the year 2015. The respondent is a legal heir of the deceased employee of the petitioner. Crux of the matter is whether the respondent, legal heir, is entitled to retirement and monetary benefits of the deceased employee or not. The petitioner department disputed that deceased employee was regularly, his services were regularized. To stop. Perusal of the records, it is evident that deceased employee services were regularized on 7/2/2000. Whereas the respondents are of the, the petitioner's department is of the view that an officer who has regularized the services of the deceased employee on 7/2/2000 is the postmaster, Gopalganj, head office, is not the competent authority. Therefore, it was cancelled by means of a communication by the superintendent of post offices, Sivan Division, Sivan. However, perusal of Annexure 2, such communication in respect of cancellation of regularization dated 7/2/2000 is not after due notice to the deceased employee. To stop that apart, The petitioner's department have not apprised this court who is the competent authority to regularize the services of the deceased employee. Full stop. Today, Land Counsel for the petitioner relied on the notification dated 12 December 2010 relating to rules called the Department of Post Multi-Tasking Staff Recruitment Rules, 2010. In terms of the rules 2010, the competent authority to regularize the services of ad hoc employees is by a committee constituted under the rules 2010. First of the aforesaid submission is not the clinching material evidence against the deceased employee for the reasons that deceased employee was entitled to regularize his services in the year 2000 and not in the year 2010. Full stop. At this juncture, Land Counsel for the petitioner seeks time to get instruction release this matter. After 10 days, it is made clear that no further time would be granted for the reasons that petitioner respondent LR of the deceased employee is awaiting for certain monetary benefits from the department petitioner from 2012. After 10 days, other than Friday. Why these are all connected matter? Union of India, you must answer.
Connected meter.
Why this CWJC 7760 is connected with this?
Clerk, yes.
My lord, of course, certain distinctions are there, your lordship. But my lord, the case is ki all are widow of deceased employee, except my lord one serial number. Third case, your lordship. Oh, do hai.
You are appearing for respondent.
Your lordship.
What is the date of regularization of the respondent?
No, so far, my lord, second case is concerned Meena Devi. Her husband was not regularized. He died, my lord, as temporary status at par with temporary Group D employee.
No, what is the date of giving temporary status?
Your lordship.
No, her husband was working as a employee.
My lord.
Meena, what is this?
Meena
Meena Devi is a legal heir.
My lord, she is the widow.
Say so.
My lord.
No, this Bara Chakai, what is this? What is the name of the deceased employee?
Vijay Kishore Prasad.
Your lordship.
Vijay Kishore Prasad. He died on 15/11/2007.
Late
Was he given temporary status?
Your lordship, temporary.
On what date?
Just my lord, I am giving.
You want to do library here?
My lord.
You want to do library here?
Since my lord, I was fully prepared in item number 1.
You people don't read and come?
My lord.
Matter is of the year 2015. Please understand, Mr. Counsel.
Your lordship.
And it relates to pension and retirement benefits or something that have some seriousness in the matter.
My lord, temporary status was conferred with effect from my lord 23/10/1992, while order dated 8/10/1993. In paragraph 3 of the order passed by learned
No, if
tribunal.
an employee is given temporary status, in that event, is he entitled to retirement benefits, pension benefits?
My lord, that is the case, your lordship. After rendering 3 years of continuous service, after my lord temporary status, his status becomes to my lord at par with temporary Group D
Where is
employee.
that provision of law?
My lord, your lordship. That rule has has been considered, just my lord, I am referring. My
Who
lord,
is appearing for Union of India?
One was the case, sir. Meena Devi.
Sri Rakesh Kumar Sinha.
in paragraph 2 of the order, your lordship, the consideration of rule is there. I am referring, my lord, next page, internal page 2 of the order passed by the learned tribunal.
This is also postal department.
Same.
Your lordship. My lord, my lords.
Rakesh Kumar Sinha is no more a panel counsel.
Yes, my lord. Mr. Rakesh Kumar Sinha is in the panel. He is in another court, my lord. And Mr. Rakesh Kumar Sinha is also in the panel as the CGC. He is on another court. He has left his file here, my lord. And actually, additional Solicitor General was to appear in the matter, and therefore we were in other way relaxed in this matter because he has to argue.
Oh, relax means what?
Since our senior
He has to relax or
No.
the judges have to relax?
and he was arguing in the Chief's Court in the item number 4, though the file is here, my lord. I will try my best to assist your
Sir,
lordship as per the.
you people should give preference to these old cases. 2015 matter, that too matter relates to retrial benefit. LRs have come on record.
On the next date, the matter Union of India versus Mahendra Prasad, that is my matter. I will give a serious argument, my lord, on that day. Earlier also I have argued that matter, but later on it was decided that 3 additional solicitors will argue the matter, and therefore we have thought that he is ready with the brief. But he is in the Chief's Court in the item number 4, my lord, and it is continuing for more than 1 hour. We have repeatedly gone to him, my lord, and therefore the difficulty has occurred, my lord.
What is this number is given here? Shall I record? None appears for the petitioner.
It will affect the council, my lord.
It has to.
My lord, I can only say since that all matters are tagged, my lord, and it is to
Which is your matter?
uh,
It is listed today. It is listed today in CL number 37.
yes, serial number 37, I am there, my lord. And in all the matter, issue is only one, the same, my
Sir,
lord.
we forget about the issue, sir. You have filed wakalat in the CL number 37.
Serial number 37, I filed my appearance, my lord.
You have filed appearance.
Yes, my lord.
Then address the argument.
The
The
only
case in which you are ready, just mention it. In which case you are ready in the amongst the tag cases?
in all the cases, since additional has to appear, my lord,
Hardly matters if he is not there.
the only
Not
issue
here.
in this case is to be decided, my lord. The persons, once the service is regularized, he is entitled for the pension.
Or not.
Here is the case that these persons has been granted temporary status, their service has not been regularized, and therefore they are not entitled for the pension. The court has, tribunal has directed for the direct payment of the
No,
pension.
why their services have not been regularized? What is the reason?
Because the council earlier already said that there was only 25% of vacancy for them, and only 2 persons has been regularized out of these about 10 or 16 persons, my lord. I have not the complete list for the present, my lord, because I have the details of them, my lord, and that's why
So
they
when
have.
are you, how many years you want to collect all those details? Now it is already 7 years lapsed.
Since
In the present case, how many years you want? One more decade?
one date only, my lord.
Sir,
On-
it is, the present matter
Only
is,
since
present matter is adjourned from
since the-
four times to 7 times.
since, my lord, on the earlier date,
All right,
It-
we'll adjourn, subject to payment of cost.
uh,
In each petition, 10,000 rupees. Let them have at least that benefit. Yes, take down. In the connected matters, CWJC 7760 of 2015 till last number, learn counsels for the petitioners seeking time to get instructions. Full stop. All these matters are of the year 2015 to 15 and 2016. Perusal of the records, it is evident that the matter is being adjourned on from 4 occasions to 7 occasions. Full stop. It is to be noted that each and every respondent is seems to be legal heirs of the deceased employee. Their grievance is the deceased employee is entitled to retirement benefits, and a respondent legal heirs are entitled to family pension benefits. These matters are pending for the last 7 years. Full stop. For seeking adjournment in these matters, imposition of cost is warranted, and it is quantified at rupees 10,000 in each of the petition. The petitioners department are hereby directed to pay a cost of rupees, pay the aforesaid cost before the next date of hearing. If the cost is not paid to each of the contesting respondent, matter would not be heard on the next date of hearing. Release this matter after 10 days.
my lord, then cost has to be paid to the petitioner counsel.
Petitioners,
Sir,
sorry,
respondents
respondent,
The
Legal heir.
concerned legal heir,
This
the
is
name, the respondent concerned.
It will be very difficult, my lord, to search them out, my lord.
Through the respondent counsel.
alright, cost shall be remitted in the registry. The registry shall disburse the cost to the respective respondent, legal heir of the deceased employee in each and every case. You deposit in the registry.
My lord, since in the first matter no cost
First matter he has argued.
and all the matters are the same, my lord.
No, how can it be same? Same. He has argued. We have given him direction. What are the instructions to be obtained? Yes.
Obliged, sir.